We drum in that messaging around the dangers of COVID pretty diligently for a full 2-week period of sustained propaganda.
Just waiting for Brent to jump back in, and we're going to be talking about the legislation side of things now. You're going to hear a little bit more to help other people learn how to do this yourselves, not depend on lawyers for child whose first duty is to the court and not to you. They're only interested in making the money. The courts are only interested in the traffic going through it. It's all money to them. It's just a big cash cow. So Brent's going to jump in, and he's going to go through some legislation, the different parts of the acts, of different sections of the acts, so you guys can learn how to do this yourself. I'm going to be going through this and editing it up and making sure you can see all of the parts of the legislation that we're talking about. And yeah, all things going well, will be sweet as beans. So just waiting for Brent to jump back in. I've sent him the link. We'll see what happens. All right, here's Brent. Brent, bro, it's been too long.
Yeah. Oh, you're one of those ones with the monster drinks, eh?
Yeah, I thought I'd switch from Coke because I don't support Coca-Cola. Monster drink. Some sponsorship would be nice, Monster. That's all I've got to say. Anyway.
Yeah. If I could keep the belly down, I'd drink that stuff too.
Can't bet the thoroughbred. That's what Mum always told me. Anyway.
Well, yeah, fair enough. Didn't she tell you date of birth?
Date of birth? 1972. Apparently I was there, but I fucked if I know what day it was. Mum tells me it was the 6th of July. But
yes,
then,
I remember seeing the video, but you can't believe Mum because she told you about Santa, eh?
yeah, Tooth Fairy, the lying. I'm not going to get a straight answer. Anyway,
Exactly.
Righto, where do you want to take it from, bro?
I think probably the best one to take it from would be, most of the time they tend to do, okay, every one that I'm hearing about is a Section 39 place of safety warrant. Okay, yeah. But I think the most important one to go with, first of all, home for life.
Section 1.
Because it's not home for life. Yeah, it's not home for life at all.
Okay.
I mean, people hear Section 101 and the first thing they think of is home for life. But what's required for home for life? Do you know what's required for home for life?
No.
Okay. It used to be a Section 67 declaration. They've repealed that. Okay. So how, like, all of the uplifts are based on the fact that you have to meet the grounds of, and this is the strange part, you've got to meet the grounds of a Section 68, which is the care and protection concerns held in regards to the child. But in being able to do that, it also brings into it the Oranga Tamariki Section 14.1, normally A and E. Under A, it's normally 14.1A 1 and 2, because they've got to be able to set the grounds for the care and protection. But here's the silly part. Even if you get a report of concern, okay, and that comes up unfounded, or they can't find anything wrong with it, okay, what you'll find is to get the 101, you still got to be able to have the 68, but they turn it into more like a declaration, like was 67, Section 67, okay, and the one thing that really gets me, that everyone I hear for home for life, okay, I always used to think home for life was home for life. Okay, but then when they started doing last year, the ones that Newsroom reported on, the reverse uplifts, like the couple down south that had the kids, and they reverse uplifted them from them. So if it's a home for life, where does the home for life part go when you reverse uplifting? So that made me think about it and look into it. And under section 101, 101 is just a more, how would you put it, a more solid version of a 78. Okay, but both 78, section 78, which is custody, okay, and section 78(1), which is interim custody, still require section 68 to be able to give the grounds for care and protection. Because section 68 is the affidavit they are supposed to do up in regards to the care and protection concerns. But for them to be able to have the 68, they require section 14(1)(a) and E, and normally that will lead into section 14(AA) and the different subsections under that. The problem is, where things go wrong, they have they might have a report of concern come in. They'll go and check out the report of concern. My belief for these days is if they don't like you as a family, then you're screwed anyway, even if it can be proven wrong.
Because it's all personality contest, isn't
that's
it?
just how they do things.
It's a personality contest.
Exactly, yeah. So if you come across as being a whānau that will fight back, then you're going to have problems. Like, that's what they do. But you see, the thing we've got to get used to as whānau is this: how many years are we going to keep jumping through how many hoops just to get told in the end, child's not coming home anyway? Okay, and you know, when you get social workers that turn around and they'll put in the FGC plan, that yes, there is a real likelihood that the child will be returned within 6 months. Okay, based on the fact that they've got you to agree to all of these other different things that need to be done. All of a sudden, you need a mental health assessment. All of a sudden, you need a psychological assessment. All of a sudden, you're one crazy bastard.
Yeah.
Okay, but I spotted one
because you're putting up resistance.
That's right. But one guy had a very good point on a Facebook page. Okay, the minute and he's proven this fact apparently. The minute you turn around and state to them, "Okay, I accept what you're saying. Could you please pay for a mental health level 4 course for me to go through?" Well, that course is $8,000. Okay, the bad part, if you come out the other end, okay, and you qualify under it, it qualifies you as not only as a social worker, but as a psychologist. So, as he put it with one of the people he was helping, he put it forward to them, okay, she will go and do a mental health assessment thing, okay, a course, if you can pay for it. Wasn't it strange that a week later, all of a sudden, the OT had no concerns about her mental health at all?
Yeah.
So, well, hold on a minute. What are you talking about? You had the concerns a week ago. They can't have just disappeared. But no, because he wanted to put it, he suggested they put her on that course, and that she was quite happy to do it, providing they met the cost of getting to and from, and all that stuff. That she would do it.
So if Oranga Tamariki are happy to pay $8,000 to $10,000 and give her a psychologist degree at the end of it, then sure, by all means.
Well, it would look pretty stupid for them in the end because, okay, you're coming out a qualified social worker and psychologist, so you're able to kill off the two things that they're accusing you of. So, you know, when it comes down to, oh, really, because I'm qualified as a clinical psychologist now, and I don't see that problem.
Yes.
You know, but that's where it comes down to. Okay, Section 101 is founded, in my opinion, off Section 68, which requires also Section 14(1)(a) and E, normally subsections 1 and 2. Okay, and to get into that category, you then have to go to 14(AA). Okay, and so what gets me the most is the fact that whānau out there don't realise this. Okay, 14(1)(a) and E. Okay, is the basic care and protection concerns. Then you move into 14(AA). Okay, and you go into, if you look through that section, you'll actually see that you can actually get them to meet more of those care and protection concerns against them than yourself. And then you follow that with Section 5(1)(bv), okay, and you bring in the Unicrop Act, okay.
Hang on.
So what ends up happening?
Section 5, did you say?
Yeah, if you look up Section 5, it'll be. I'm pretty sure it's Section 5, subsection 1, subsection B, subsection V. 5.
going down, which
Okay,
is
that's the main one.
decisions should be
That's the
made.
main one that they.
Decisions
Sorry,
should
what was
be
that?
made. Decisions should be made and implemented promptly and in time frame appropriate to the age and development of the child or young person.
Yes, and so they try to include this in the fact that, okay, not only do they have care and protection concerns, okay, but they're trying to make them as solid grounds as possible so that they can do the 101. Because where they repealed Section 67, which was the declaration for being able to get a 101,
Yep.
okay, basically you now require 68, 14, 1A and E, I think it's 1 and 2. The other acts I was telling you about, the sections 14, AA and E. Now, if whānau out there are clever enough, okay, you do what we did and you put 21 of those sections together. Now, if they're only using 5 sections to be able to say, we've got care and protections against this family, what does 21 do in a court? Nothing. Why? Because we're not the organisation OT putting that in. But when you've got a child that's been abused, okay, it's not taken seriously because you're bringing up all of the parts of their own act that they didn't bring up, okay? So then that's when they require to get heavier counsel involved to start blocking you, because all of a sudden it becomes pretty obvious you are aware of what their act can do. Because otherwise, why did you put 17 sections of their act, a Family Violence Act section, just pretty much, if they were to put it against you, okay, you would never see a child again in life. Okay, but it doesn't work the opposite way around. They don't take it as seriously because this organisation should know what they're doing, but they don't. No. In my opinion, they don't. Because if you can turn around and deem children to be safe that are being abused, what right do you have to uplift them in the first place?
None.
And so Home for Life, as they state, Section 101, Home for Life, okay, is not Home for Life because any whānau that are listening, Section 125 of the Oranga Tamariki Act, okay, that is available to vary or discharge the orders, providing that, okay, this works, in my opinion, for whānau that have done nothing wrong, or if there has been accusations made and, okay, you agree, yes, there is problems, but you've, for instance, gone and done the courses they want done, okay, but you jump through every hoop they want you to jump through, and then the next year there's more to go through, and then the next year there's more to go through. Okay, so they do it so that you're never ever going to. Yeah, so like a good example of that was the one that was done in Lower Hutt, where we are, about roughly in the last couple of months, where the judge under Section 7A released the child to the maternal to the grandmother that had come over from Australia. The reason that had been done was because she'd come over and OT had made her jump through so many hoops during the 2 years that she was here, trying to get her grandchild back, that the ruling on it was, and it was written up in the paper, that, or in the news, that because she applied under 7AA and she was under Section 126, she's a wider whānau group. This is another thing that a lot of whānau are not aware of. Okay, so I'll go through them one by one. Okay, Section 101. Okay, you are led to believe that you cannot get your child back. Okay, that child will be under the care of OT for life. Okay, Section 126 of the Oranga Tamariki Act states, okay, I think it's E and F, the wider whānau group can also apply to be able to discharge or vary custody. So if you're part of
any member of that child's or young person's whānau or family group, you're exactly right. 126.
Yes. Yep, so Section 126 states that, and that's how we got into the court case. Okay. Now the thing is, when it comes to 126, you pair 126 and 125 together, because what people are not aware of, okay, is that when if your child's ever been under the Care of Children Act, okay, and OT become involved, and they manage to get orders, what happens is, I'm pretty sure it's Section 120 of their Act states that you cannot have anything done under the Care of Children Act. No other act can be implemented in regards to their act. So basically what happens is you go under there, you're thinking, okay, we were under the Care of Children Act, so you start applying under the Care of Children Act to do a discharge. The problem you've got, and even if a whānau member applies for custody under Care of Children, okay, it cannot be done because OT section 120 says it cannot be done. It's a restriction on using the other acts. Okay, so
restrictions on making of guardianship and parenting orders under the Care of Children Act 2004. Correct.
Yeah, that's what I was meaning. Yeah, so you can't use the Care of Children Act. Like if they come and take your child, you've been under the Care of Children Act. Okay, what people have got to realise is that once OT become involved, that section stops you using the Care of Children Act. You cannot discharge an order under the Care of Children Act the minute Oranga Tamariki gain an order. Okay, so if they get a place of safety warrant, which is the section 39, and then they have that, they've got 5 days. If they uplift the child under section 39, they've got 5 days in which to go back to the court and go, we have the child. Then they can apply for the 78, section 78 or 78.1. The important thing to know about that, okay, section 39, the 5-day part comes under section 45. Okay, now, the important thing to know, because whānau don't know that, okay, the minute they go and get a section 39, it's like, oh, the child's gone. Okay, yes, the child has gone. The rights you have, though, to be able to stop them getting that section 78 straight away within that 5 days is file a notice of intention to appear. Once you file that notice of intention to appear, it's not an automatic custody order. It stops it's basically like putting an injunction in. Okay, so what you're saying is, I intend to appear in the case, but it's the same thing with FGCs, a 128 plan. Okay, if you go to an FGC and you go, I do not agree to care and protection issues, they will hound you into trying to get you to agree to that. If you refuse to agree to that under the 128 plan, okay, because they've got to file, I think it's either section 28 or 29 where they've got to file the plan with the court. Okay, so what ends up happening is you don't agree to the care and protection. So you're threatened with you're going to lose your child.
It's
okay.
29. Yep.
So the minute you leave the FGC, what you do, you start calling the court. Sorry?
It is section 29. Family
Yeah,
group.
I knew it was either 28 or 29. It's one of those two, yeah.
Decisions and recommendations and formulate plans. Yep.
Yeah, and so under the 128, if when you're doing the 128 plan, like if you go there to do a 128 plan with the FGC and you say no, there's no care and protection concerns, their first avenue is they will go and apply to the court for a section 78. Okay, whānau don't realise, okay, that all you've got to turn around and do to stop that happening and get yourself heard in the court too, file the notice of intention to appear, because the minute you know that they've gone to the court, as long as you file it within 7 days, it's not an automatic thing for them to get the 78 anymore. It's okay, we'll set a judicial conference date to get a hearing done and we'll hear both sides. Okay, so your child's not going to be uplifted for that.
I'll point out the reason for that, and it's just like a speeding ticket or anything else that the government put to you.
Yep.
Silence is acquiescence. If you say nothing, you're accepting to what they're saying. If you show up resistance or say something or no, you're not having my authority to do it, then they have to follow the procedures. If you shut up,
so basically,
straight over you.
Yeah, but basically what you're doing is you're turning up to an FTC, you're going, no, I don't agree, which is saying, no, I don't consent to having this meeting. From there, they try and go and say, right, well, then we're going to have to go to court. Well, then go, fine. Okay, I'll see you in court. Because what they'll say is we're going to have to go and get orders. We don't think to ourselves, let's go and see when they've filed. And so what you do is you ring up the court, you give the child's name, okay, that you're dealing with, okay, and you ask, has anybody filed any applications? The minute you find out an application is filed, okay, you ask for the FAM number and you file a notice of intention to appear. Because from the time that they enter the application for the 78, you have 7 days to be able to do a notice of intention to appear. Where whānau get caught out, they don't know they got 7 days. So naturally, the OT go and file in the court. Nobody knows this is happening. So you lost the custody.
Time runs out. You've lost.
Time runs out. And you think, if you go and you put in your notice of intention to appear, that normally takes it out for about 8 weeks, and each party has then got to get the evidence and say, well, OT's going to go, well, this is why the child should be taken, and you're going to go, no, this is why you shouldn't take my child. Okay, without that notice of intention to appear, which is a pretty important document in these cases, okay, your child's going to go because you don't know your rights.
You're just acquiescing. Yep, you're proving you're stupid. Don't know what you're doing. Yep.
Yeah, and so then what they do is they also use that part to go along and go, well, okay, if they were silly enough not to check up on that, what are they going to do in regards to their child? And then they're using more care and protection concerns. And so they try and build their case off of these things. And what makes it very hard for them is when whānau know their rights and you bring them up and go, well, no, under this section, you can't do this. Okay, under this section, I can apply to have my time in court. And they don't like that because of the fact that, okay, we've now got whānau fighting back. And so if you get enough whānau fighting back, what are we not going to have? Kids in care. Okay. I do say though that, okay, where we do have whānau that are having difficulties with children in that, okay, and it's a proven thing, then okay, yes, you still want to put your notice of intention to appear in, because you should still be able to have the chance to make the changes and not under the thumb of someone else. Because as we all know, that if we get forced to do something, we're not likely to do it. But if we can put our side forward, and then we can turn around and say, okay, well, I mean, if they want you to do all of these different things, okay, and you're happy to do it, make it at their cost. You pay for me to get to it. Yeah, you're saying I have to make the changes. I'm saying, okay, I'll agree to that if you do a family group conference, okay, but you make them pay for the cost, because they're the ones saying you need changes.
Is there anything in law that states that you have to pay for them or that they have to pay for them? Do you know what I mean?
Not that I have seen, but okay, when it comes down to it, okay, if you want to be able to make sure that they are paying for, like say if they say you need to go to, I don't know, it might be a hospital 20k away to be able to do mental health assessments. Okay, that's fine. Then under Section 92, you give me a support order to say that I've got to go to it and that you're going to pay for me to get there.
Nice. So
okay, because they have, the problem is they've got support orders, okay, but the problem is this is another important thing when it comes to support orders, okay. Whānau have got to learn and got to be aware support order is not a custody order, okay. I know of a few cases at the moment where people have OT involved in their lives, okay. OT are telling the kids where they can and can't live, but OT have only got support orders. But the parents are led to believe we have custody. You will do as we say.
So they think they've got authority when in actual fact the parents still have it.
Because they're handing them a piece of paper and they're taking it as being a court order. The court is only saying, okay, whatever support this whānau needs, you are to give them.
Really?
Okay, that's all a support order is. Yeah.
And
so a support order is just
by that support. Are they bound by the court?
Yeah. So, like for instance, if you got so a support order can work on custody, or if the child's placed with you, it could be a case of okay, we're going to leave the child with you, but the court is ordered. Okay, it might be the court, the Oranga Tamariki have to support the child through school, buy the school uniform, buy the books, any trips they got to go on.
Sure.
So. But they're making people think that these orders that they got is for them to tell them what to do.
But it isn't.
There's a lady I know of that I was trying to help her up north with. She wanted to be able to, she was worried about the custody of her children. Okay, so I was helping her put together her thing, her case, and to be able to do it. Okay, and then she comes back and she says she took the paperwork down, the court wouldn't accept it. Okay, I said I don't understand it. Why not? Well, they said I've got Section 92. Hold on a minute. You telling me they're leading you to believe that your kids are living at different houses because they had made them her kids live at different houses. Okay. She couldn't have 3 of her kids with her. Okay. This is what OT said then, all on support orders. Okay. Then I find out one of them is 16. One of them is 17. Okay. Both of these ones are in a relationship and have been in for over a year. Okay, which meant Section 108D came into effect, because if you're over 16 and you are in a civil union or de facto relationship, immediately the orders cease to exist. You just have to file for them. And it's not.
Is there a length of time that relationship has to exist before it's acknowledged?
All it states is that you have to be in a civil union or a de facto relationship. Basically, you've got to be living in the same room as the other person, in a relationship. Okay, so as long as you're in a relationship, that's it. 108D gets you out of it. Okay, and the thing is, they go back to, this is the biggest mistake whānau make. Anything change they're trying to make, what they do is they say to them, okay, well, we're not going to apply to the court for it. Okay, so they think to themselves, I'm stuck. No, you're not. The child or young person can make the application themselves after the age of 16.
Wow.
You can literally go down to the court, you can ask for a substantive application, put it in front, get it written up, get some help to get it written up, put it in front of a judge, okay, and as long as you can prove you're in that relationship, that's it, 108D applies. The order is gone.
The only proof you'd need is like an affidavit from the partner.
Yeah, to say you're together, okay. And the other way is, okay, normally if you've gone in a de facto relationship, okay, and you're receiving money, where are you normally getting the money from? Wins. So they've got you listed down as spouses.
Exactly.
So it's not hard to get out of that.
Yeah.
Yeah, and it's like, yeah, there's other different sections where, like guardianship wise, okay, they can't turn around, under the Oranga Tamariki Act, I'm pretty sure it's section 115B, okay, you can dispute a guardianship problem that's happening. Okay, so for instance, if you, like, okay, good example, COVID injections, if you didn't want your kids to have COVID.
It's 115, there is no B.
Was it 115? Yeah, I knew it was either 115. I think it's section B, subsection B.
Subsection
Is that right?
B. Okay, I'll have a look.
Yeah.
Just a moment. Come on, computer, load up. The one time I want it to show me something quickly.
Yep, exactly. That's what mine does too.
Yeah. No, it's just decided
The biggest thing.
That's all right. Carry on.
The biggest thing I would put out to people out there is, okay, getting that knowledge is what gives you the power over them. Okay, because
power.
Well, most of the acts, in the beginning of the act, it always says acts binds the crown. So, we're all led to believe that, okay, these are government rules and they're the only ones who can use them. And a lot of the people that I've spoken to say to me, well, how do you go about it though? Because they've got their act to use. Yeah. So when we go and ask them about the section of the act, they go, no, there's nothing you can do. And I was like, yeah, of course they say there's nothing you can do because they don't want you to be able to use it. The way you use it is you put it in an application to the court, and then that way it's their word against yours when you make the application, your evidence against theirs. And so that's how you get that into play. But a really important thing that when whānau are fighting through the family court, and you find that, okay, no matter what you do, like there's cases that have gone on for 10, 15 years, okay, and you're getting absolutely nowhere in the family court simply because most of the time you've got a judge that just doesn't care, and so they case manage them. And so when you're getting a case managing judge, okay, you're never going to get anywhere because that case, I mean, for instance, I know of a case where the judge has actually turned around and stated in his minutes, okay, I agree with Oranga Tamariki, this should not happen. Okay, so my question to that is, where's the impartiality?
Exactly.
Okay, you're not supposed to be turning around and you're not supposed to be turning around and agreeing with the government organisation. You're supposed to be giving a separate, my description to people is this: okay, you give your evidence, they give their evidence, and the man or woman in the black gown, they make the decision. So if you went to court and it worked fairly like that, you might actually get something, but it doesn't work fairly like that.
Yeah.
And so when you've got
dodgy, corrupt fucking referees in the middle.
Exactly. And so when you've got that happening, you've got two shows, shit and no.
Yeah.
And so at the end of the day, all you can do is do what, the easiest way for a whānau to deal with that sort of problem is you go and you get an originating application to go to the High Court, and under the Family Court Rules 2016, you apply under Rule 19.2 in subsection G, okay, and that subsection, okay, takes you into section 89 of the District Court Rules 2002, District Court Act 2016, sorry, okay, and under that section, anything that is going through the district or family courts, okay, providing you have good reason, which is basically, okay, I'm not getting an impartial decision, okay, then there is no reason why you can't bring your case into the High Court where evidence has to be heard to get the verdict, basically. Instead of mucking around for years and
that's the whole point of bringing it into the High Court.
Yeah, instead of mucking around for years and years thinking, okay, I mean, there's plenty of whānau out there that have got their OIA files, they've got their evidence, but they just don't know how to get it in front of the court. And I honestly believe that if they did, a lot of people were self-representing. If they are comfortable doing that and feel okay speaking for themselves, then self-represent, because what you're going to find is you're dealing with family court lawyers that are legal aid lawyers. Okay, all they're interested in doing is milking the system for as long as they can, because while they got you as a client, they can just keep milking that system. Okay, and when you work out that on average, it's normally an average of $12,000 a year that legal aid will pay per client. Okay, and so they don't care how long you're in the system, because they can just keep milking that system. I mean, I know one lawyer firm down here, I think it was 2019, going by the records I saw, that claimed $500,000 for legal aid. You know, there's firms up in Auckland that I've seen on the same list that claimed, what was it, a couple of firms with $2 million, you know, and legal aid. And it's like, okay, so
I have got the entire spreadsheet of what legal aid paid out to every lawyer in the country. I haven't even totaled the
and you'll
amount,
probably find it's probably,
but I'm over $400 million so far as to how much was paid out just in that 1 year.
Yeah, and so it shows you, okay, for the whānau out there that are listening, it shows you that the reason you're getting nowhere in your case, unless you've got a good lawyer that's actually deciding to do it by the books, okay, the reason you're getting nowhere is because of the fact that the longer they keep you on their books, the more money they make. And so, yeah, there's less, that you don't have to go and get as many clients because you're milking the system that way.